Was that charge constitutional?
Well,
so can you explain it to me just in clear terms?
this is what is so tremendously dangerous about the precedent.
So is that legal?
No,
Didn't Hillary Clinton? So is this a different thing?
she was found to have done what Bragg is saying Trump did.
Is he going to end up in prison?
This is not the way things should work in a fair and just system that needs to establish its impartiality and to show you that it's not behaving as a political weapon.
So there's a question about corruption there.
The whole thing is so embarrassing. What a mess.
The impression I've got from hearing you speak is that there's a pretty strong bias.
I'm very worried about it. I think every American should be.
Hello and welcome to the Winston Marshall Show with me, Winston Marshall. I sat down with constitutional lawyer, Yale professor and expert on the First Amendment and free speech in America, Jed Rubenfeld. Jed is also representing RFK Jr. in the Biden, Missouri case that we are due a verdict on very soon from the Supreme Court. We took a deep dive into all the ongoing lawfare in America, particularly or specifically surrounding the two presidential candidates, Biden and Trump, and just a little bit on RFK Jr. So I should say three presidential candidates. We look at Steve Bannon being called and sent to do prison time. We look at the Biden, Missouri case. We look at Trump's 4 indictments, as well as a deeper dive into the New York case. We also have a look at Hunter Biden and his felony charges. And I think that's kind of the scope of it. All of that. And he's really a great mind and one of the leading scholars, legal scholars in America. So it was a real pleasure and honor for me. Before you hear from Jed, if you want to support the show, all you have to do is press subscribe. If you press subscribe, I can have more phenomenal guests like Jed Rubenfeld discussing the issues that you want to hear about. But without further ado, Jed Rubenfeld. Thank you for watching the Winston Marshall Show. Jed, thank you for taking the time to speak with me.
I'm very happy to be here.
Now, as well as being the YouTube lawyer, you are also a constitutional lawyer, a professor at Yale University, an expert on First Amendment law, and you are one of the lawyers involved in the Biden, Missouri case.
That's right.
So I want to get to that. I want to cover these things. I don't fully understand this thing, not least because if you try and get into this kind of stuff online, there's a miasma of opinion that cloud any sense, and it's hard to get to the fact, let alone to get to the legal, beneath it, what is actually the truth, I guess, beneath it all. So I'm hoping you can clarify that and my audience who are eager to learn. Let's start with Trump.
Sure.
He has just been found guilty of 34 felony charges in a New York state, in a New York court. In your opinion, or not in your opinion, as your legal opinion, was that charge constitutional?
Well, let me answer it this way. There are very serious and numerous constitutional problems underlying that whole prosecution. And I can explain them to you. And
I want a yes or no.
I can walk you through them. What we really need is a federal court to adjudicate those issues. And this is a very serious problem for us. We have a potentially unconstitutional conviction, which might swing the election. So if so, that would be entirely unlawful and irrevocable. That is, Trump's conviction will not be reviewed by the appellate courts in time to have any by the time they get to the case, the election will already have happened. So you could have an election that is swung by, determined by an unconstitutional conviction brought by a district attorney in New York, and without ever getting any federal review of these serious constitutional issues. So my position on it is there are very serious constitutional problems, way more serious than the proponents of the prosecution want to acknowledge, and what we really need is to have a federal court review these and adjudicate them in time before the election.
Jed, can you take me through it? So this is one of 4 indictments against Trump. What exactly is this? Is hush money? No, actually, this is campaign fund misuse to do with the hush money paid to Stormy Daniels, and via Cohen, his Trump's former attorney. Is that right? So can you explain it to me just in clear terms, what exactly the charge is, and what exactly is going on?
Well, Winston, we've all been reading about this case, and the fact that it's sort of difficult for you to state what the charge was, or you need to ask me to explain it. That's part of the problem, part of the constitutional problem with the case. Normally, in a criminal law trial, after the person's been convicted, you know what they've been charged and found guilty of: robbing a bank on a certain day. Nobody's in question. Nobody's puzzled by what the charge is. You know what the charge is, and if they're found guilty, you know what they're found guilty of. That's not true in this case. You ask 100 people, 99 people in America will say they have no idea what he was just convicted of. Here's what he was convicted of, if you want to know. So, New York has a law that says you can't falsify business records. Okay, that's a misdemeanor charge in New York. The falsification of business records that he was accused of is putting down in the records of the Trump organization payments that were hush money payments to this Stormy Daniels, so that she wouldn't go public with her allegations. And they marked those down within the organization as legal expenses. So the first step in the prosecution is to say that was false. That's a falsification of a business record. That's just a misdemeanor, and the statute of limitations on that charge had run. So Alvin Bragg, that's the prosecutor in New York, the district attorney, he doesn't just charge Trump with a misdemeanor. He couldn't, because the statute of limitations around was too long ago.
How long is the statute of limitations?
2 years.
2 years.
So and this all happened back in 2016, 2017. He doesn't get charged until around 2023. So they were long gone. But instead, Bragg charges him with a felony. What felony? Not paying hush money to a woman, that's not illegal. Not having had an extramarital affair, that's not a criminal offense. He's charged him with a felony of falsifying business records with the intent of, in order to conceal a second crime. That's a felony under New York law, and that has a longer statute of limitations, and it's a felony offense. But the indictment never said what the second crime was. That's why nobody knows what the heck he was charged with. The indictment didn't say what the second crime was. And then the prosecution filed a document called an information, which is supposed to supply some more facts about the case, and it didn't say either. And Bragg did Alvin Bragg, that's the prosecutor.
Can you tell me about Alvin Bragg?
Well,
what do we need to know about
What you need to know is that, like many district attorneys throughout the United States, he's elected to office. So you run for office to be a prosecutor in the United States, not in the federal system, but in the state system. We have 2,000 or 3,000 local prosecutors in the United States. They're elected to office. They run as a member of a party. They get elected. Bragg ran on a campaign of going after Trump. He said he was going to do it. He promised to do it. He did do it. I'm going to digress a tiny bit from the legal side of this and just say this is what is so tremendously dangerous about the precedent. And I don't care what your views about Trump are. Everybody should see what a dangerous precedent this is for a legal system in a democracy. You have a district attorney who is elected from one party, and he's prosecuting the leading candidate, the presumptive nominee of the other party for president. And he's doing it on a charge that's so tortuous that nobody can even tell what the offense alleged is. This is a very dangerous precedent, because if it stands, you could have prosecutors in Texas or Alabama. They'll be prosecuting the next Democratic poll leading candidate. It will be happening all over. It's a recipe for a catastrophe in a democracy. If officials from one party can prosecute the leading candidates from the other party. Now, nobody's above the law. If a candidate has committed a serious crime and you got the goods on him and it's clear, you got to go after him. I don't care what party you're from. I've worked in a prosecutor's office. I was at the U.S. Attorney's Office in New York City a million years ago. If you got the goods and they did it, go after them. They're not above the law, of course not. But if you've got a local prosecutor elected from one party, and he's prosecuting Trump on a novel legal theory that nobody has ever been prosecuted under before. It's so tortured you can't even explain it. Then you've got a big problem for democracy. And that's the world that America is heading toward right now. And that's why I've been speaking out against this case and saying, look, there are real serious constitutional problems, and we have to look at them, and they have to be addressed. Now, to come back, so the indictment doesn't tell Trump what the second crime, the crime that he was supposedly concealing back in 2017 when he was reimbursing Cohen for these expenses and marking him down as legal expenses. So step one, you have to believe that him calling money that he paid his lawyer to funnel to Stormy Daniels, that those aren't legal expenses. That is, the prosecution's first step is that's a lie. Those weren't legal expenses. Those were campaign expenses, which is just what you said before. You had that right. Prosecution is saying, no, those are legal expenses. So those are campaign expenses, and you called them legal expenses. That was a lie. So that's the first step, falsification of business records. And if
they were, sorry, hang on. They were they were legal expenses, and he was calling them campaign expenses.
No, it's the opposite. It's so confusing. They're payments to his lawyer to reimburse Cohen for the Stormy Daniels hush money.
And the prosecution is saying that was actually campaign money.
Yeah.
That shouldn't.
Yeah, even though it's payments to his own lawyer. You might think that payments to your lawyer, those count as legal expenses. The whole case starts with that claim. Those aren't legal expenses. Those were campaign expenses. So, believe it or not, the whole case falls apart right there from the get-go if you don't accept that part. So there's plenty of lawyers in America that are saying, oh, yeah, it's obviously a lie. Those were clearly campaign expenses. He should never have called them legal expenses. And half the lawyers say, what are you talking about? He's paying money to his lawyer to enter into a contract with somebody who's claiming to have, to go public with some allegations. Of course, those are legal expenses. That happens all the time.
So that's the basic contention in court.
That's the first step. That's that's just the beginning.
Mm-hmm.
The next problem is that he was supposed to have entered those false business records to conceal a second crime. That's the only way it becomes a felony and prosecutable under the statute of limitations. And Bragg never said what the second crime was. Now, under federal constitutional law in the United States, and I suspect it's the same here, the indictment has to tell the accused person what the specific offense that he's charged with is. You can't just have an indictment that doesn't tell you what the crime is.
So how did that even get through? Is that because it's a jury?
No, it's not because it's a jury. So Bragg does an interview the day after the indictment is unsealed. And he says, New York law doesn't require me to say what the second crime is. I have to say what the first crime was, the falsification of business records. And I told him that. But I'm not required to say what crime he was trying to conceal.
Is he right that is the New York law?
Well, there's I don't know the answer. And here's why it's not important. Because New York law doesn't govern this question. Constitutional law governs, and trumps New York law. And what Bragg should have been thinking
because it was a federal case.
No, because in America, the Constitution applies even in state court proceedings. And a prosecutor cannot violate our Bill of Rights, our Sixth Amendment rights, Seventh Amendment rights. He can't do that. I don't care what his state law says he can do. But, Bragg is just thinking about New York law, and the judge was just thinking about New York law. And this is one of the things I've been saying. You can't just think about New York law. Under our Constitution, it's in our Sixth Amendment, in our Bill of Rights. Every accused has a right to be informed of what the specific charges against him are. I know it's the same in the United Kingdom. That's a constitutional rule. It doesn't matter whether New York law says he has to tell him or doesn't have to tell him. What matters is what the Constitution requires. And there's federal cases saying that in these double crime offenses, where a person is charged with, under one statute, that you have an offense under one statute that refers to another violation under another statute. That's like a two-crime offense. You got to have committed both crimes to be guilty, which is what they were doing with former President Trump. You have to say what both crimes are. You can't just say one and leave the other one a secret. You got to say both. And so there are cases that say that. And this is the first very serious constitutional problem in the case, that the prosecution and the judge never fully informed Trump what the specific charge he'd have to face at the trial was. And
why didn't Trump's lawyers push back on that?
Well,
or did they? Maybe they did.
Answer the question. They certainly made arguments of this kind. I'm not sure they fully cited the constitutional precedents that I'm talking about. I think they probably tried to argue it under New York law. I'm not sure why they made that decision. But
can they appeal still?
Yes, they can.
And so presumably this would be the argument they would appeal under.
They will certainly make this Sixth Amendment argument on appeal.
Can you tell me what the Sixth Amendment is, please?
Yeah, the Sixth Amendment is just it guarantees the accused the right to be informed of the nature and content of the charges against him. And for 150 years, the Supreme Court of the United States has said that means the specific charge. You can't just recite the statute in the indictment. You have to say what the specific charge is. Mm-hmm. And Bragg thought he could get away with not telling him because he thought in a double crime situation, I only have to tell him one and I have to tell him the other. And I think this was unconstitutional. What happened was later in the case, the prosecution said, you know what? There's three different possibilities. We have three different theories of what the second crime was. And we're not saying which one we're going to go after at trial, but here's the three different theories. So back in February, they said, here, we've got three different theories. And the judge said, that's fine. You don't have to commit yourself. You can go with your three theories. And one of their theories, now I'm really getting into the weeds here, Winch, you got to stop me. One of their theories of the second crime was a New York election law offense, which is itself a double crime offense. That is, it opens up like it means.
Wait, sorry, what is the actual?
The New York election law offense is conspiring to influence an election, his own election, the 2016 presidential election, through unlawful means. That became the second crime, the one that he was trying to conceal. So the theory, the prosecution's theory, it's very complicated, is you called those campaign expenses legal expenses. That was your lie. And you did that to conceal the fact that in 2016, you were trying to influence the election through unlawful means back in 2016 when you paid off Stormy Daniels. So the question is, what were the unlawful means? And the prosecution never said what the unlawful means were. They opened that up too. And never specified that. So you have actually not a double crime situation. You have a triple crime situation. Falsify business records to conceal a second crime, but the second crime says you can't. You did something through unlawful means. That's a third crime. Unlawful means violating some third criminal statute.
Okay, so this is one of three theories. But sorry, whose theories is this?
This is the prosecution. Had three theories of what the second crime might be.
Oh, so they did present a second crime.
And the one they finally settled on during the trial, they settled on one. They said, okay, now we'll tell you what the second crime is. It's this New York election law offense. Now, remember.
So they did say what the second crime was.
But the Sixth Amendment says the accused has a right to know the second crime, the offense, before the trial, not during the trial.
Okay,
so you can prepare your defense. So you can get your witnesses ready so you can know what you're up against. That's the whole point of being informed. It's not that you got to wait for the trial and then they tell you during the trial and you don't know. Right. It's too late to call witnesses, too late to prepare your defense. You got to be told before. Yeah. What they did was they finally settled on the second offense during the trial.
So is that legal?
No, it's a very strong argument that wasn't legal. That was a constitutional flaw from the beginning, and they never cured it. And the whole prosecution, from this point of view, could be thrown out because of the Sixth Amendment violation. Then during the trial, they finally said, okay, we'll tell you what the second crime was. Second crime was this New York election law offense. But as I was saying, this is where it gets complicated. The New York election law offense itself is a double crime offense. You conspired to influence an election through unlawful means. So the prosecution has to show yet a third crime that you were.
Okay, so what of the second?
Yeah.
So I know it's complicated here, but of that second interfering in New York elections,
yes.
What was the first crime of that two-part crime?
So the idea is, this is the prosecution's idea. This is their theory. This is what he's actually, what Trump is actually found guilty of is falsifying a business record, that is, calling these so-called campaign expenses legal offenses in 2017 to cover up the fact that back in 2016, when he was working with Cohen to pay off Stormy Daniels, what he was doing was he was conspiring to influence, to promote his own election through unlawful means. And so,
so it's almost like a circle, because the Stormy Daniels thing itself was the second crime.
But the Stormy Daniels thing, the payoff, is not unlawful. Nobody can, under American law, you can't be saying that that's the unlawful part. Paying her off, hush money, that's not unlawful. So they have to find some other third offense that he was allegedly committing in 2016 when he pays her off. They can't say, oh, well, paying her off, that was unlawful. No, that's not unlawful. So,
but also he wasn't convicted of anything anyway.
No.
So it's not how can you be cited as a crime if you're not convicted of as a crime? Or is it because it's way past the statute of limitations?
It's so complicated. He doesn't have to have been convicted of this unlawful means, whatever the state thinks it is. They can say that he was trying in 2016. Basically, they're saying you were trying to get yourself when you paid off Stormy Daniels in 2016 with that $130,000 of hush money. That was, you were attempting to get yourself elected, which he may in part have been, to help his own election, and you were doing it, and you were planning to do something unlawful to get that done. And then the question is, what? What are you saying was unlawful? That's the third offense that they had to show. And on that point, several theories were thrown out to the jury. Even in the jury instructions, the judge said, here's 3 different theories of what those unlawful means might be. I know we're getting complicated.
Is it worth looking at the other 2 or not really? They're kind of, at this point, irrelevant.
They're irrelevant. I'll mention one more thing. The judge, Mershon, says to the jury, now you got to find, all 12 of you, that there were unlawful means in this case, but you don't have to be unanimous. 4 of you could think that the unlawful means were X, 4 could think Y, 4 could think Z. He says this in his instructions to the jury. And under the American Constitution...
True? Is that legally true?
No, under the American Constitution, the jury has to be unanimous as to all material elements of the crime. And so Mershon decided that under New York law, that wasn't a material element. But for federal purposes, this is a very serious constitutional problem. Non-unanimous jury verdicts are not permitted. You can't say to the jury, find the defendant guilty of a felony if 6 of you think he embezzled funds and 6 of you think he committed bank robbery, but as long as 12 of you think he did something illegal, you can convict him. That's unconstitutional in the United States. So there's a very serious argument that Trump's right to a unanimous jury verdict was violated.
So we've still got to come to what the judge Mershon he's going to have a ruling on what the punishment is for Trump. But before we get to that, didn't Hillary Clinton in her 2016 campaign, she ended up, and this happened in March 2022, she had to pay off, she agreed to settle out of court $113,000 to a federal election commission investigating whether she had violated campaign finance law by misreporting spending on research that eventually became the Steele dossier. So is this a different thing?
You're raising a great point. So what we've talked about so far are very complicated legal issues about Sixth Amendment, right to notice, Sixth Amendment, jury unanimity. But in a way, the real problem behind this case is the problem of politically motivated prosecution. It is not constitutional in America to prosecute somebody because of opposition to their political activity, because you're trying to undermine or derail their candidacy, because you oppose their views. And every reasonable person in the United States should worry that that's exactly what was happening here. You have a Democratic district attorney going after the Republican presumptive nominee. Who doesn't believe? Who thinks that anybody else would have been prosecuted for this offense other than Donald Trump? This is a very serious problem, but the law has made it very difficult to prove political prosecution. That is, the courts have demanded a very high level of proof. You can't just come in and say, well, we think it was a political case. You basically have to show that there was somebody else who committed a very similar crime, and the prosecutor didn't go after that person, and that person had a different political view. And the only reason why they went after Trump is because he was of one party, and they didn't go after somebody else because he was of another party. I know I'm giving you a long-winded answer.
Yeah, but so for Hillary and the Steele dossier, which of course we now know to have been intentional to undermine Trump without evidence, and this is worth repeating, and it's not germane exactly to this whole conversation, but the person behind it, the source behind it, admitted that they didn't have sources, that it was speculative. Examples like the P video of Trump in Russia, there's no actual evidence of that whatsoever. But with Hillary, she is settled out of court. So that sort of presumes she didn't fight it very far then.
She was found, you put your finger on exactly, Winston. She was found by the Federal Election Commission, the United States Federal Election Commission, to have done what the New York prosecutor is saying Trump did, is alleging that Trump did. She was found to have misreported campaign expenses as legal expenses. That's what the FEC found.
Right.
She took these. She funded the Steele dossier, exactly what you're saying.
Yeah.
And instead of reporting that as a they didn't want to admit that's what they were doing. So they hid it by calling it legal expenses. And the FEC said, those aren't legal expenses. You were doing that. That was opposition research. That was a campaign expense. And you can't call it a legal expense and not report it to us as a campaign expense. So she was found to have done what Bragg is saying Trump did. It's very similar. Falsely reporting campaign expenses as legal expenses. And her campaign was based in New York City. And the New York City District Attorney's Office, Bragg never went after her. They didn't prosecute Hillary Clinton or anyone connected to her campaign for that offense. And that looks very bad. That will be Exhibit 1 in the Trump lawyers' appeal when they say, we can prove to you, we know it's hard to prove, but we can prove to you that there was selective, politically motivated prosecution here. Because look, Hillary Clinton did something very similar to what you're saying our client did.
Mm-hmm.
It's almost the same thing. She was found to have taken campaign expenses and misreported them as legal expenses. And you didn't go after her for falsifying business records to influence a presidential campaign, but you're going after Trump for doing the same thing.
Mm-hmm.
And that's the kind of evidence that an appellate court could say, that satisfies our high level of proof. This was a political prosecution, and we're going to dismiss it for that reason.
Uh-huh. Will it get to an appellate court?
It will eventually get to an appellate court. The problem is it could be years before it does.
Okay, so then let's go back to we're awaiting judgment from Mershon.
Mm-hmm.
What should we expect? There's 34 felonies. Is he going to end up in prison? When would that happen? If he appeals, how does this affect the presidential election? What do we need to understand here?
So, sentencing is scheduled at the moment for July 11th. On that day, presumably, if everything goes the way it normally goes, Judge Mershon will enter a judgment of guilt based on the verdict, and he will impose a sentence. And he is free. It's completely up to his discretion to impose a carceral sentence, jail, on Trump, or a probationary sentence. Probation is non-trivial in the United States. You can't leave the state without permission from governmental officers. You're subject at any time to search without your consent. You can be hauled up on other charges not based on proof beyond a reasonable doubt, which is the normal American standard. You can be found guilty of other offenses on a much reduced standard if you're somebody on probation. It's very restrictive.
Mm-hmm.
If he puts Trump in prison, that will obviously have a huge effect on the campaign, because Trump won't be able to go around the country campaigning.
Mm-hmm.
He won't be able to do anything. I will be surprised, although I think it's possible, that Mershon will dare to try to imprison the leading candidate of the Republican Party.
You think it's unlikely that he will?
I will be surprised, but a lot of...
So what do you think is more likely?
I think a probationary sentence is more likely,
okay.
But I've been surprised by a lot of stuff in this prosecution, okay. So it might happen again. So either way, there's going to be very significant limits and restrictions, whether he's in jail or just on probation, that...
And there's talk as well of house arrest in Mar-a-Lago. Or...
They could put him under house arrest. They could continue the gag order, which we haven't talked about. Judge Mershon imposed, and at the moment is still imposing on Trump, a gag order that says if you say certain things that are criticizing this prosecution, I'll throw you in jail for that. I'll hold you in contempt of court, and I can put you in jail for that.
Uh-huh.
So that's another serious problem. So all of that's going to happen on July 11th. We're getting very close to the election. And so, what are the chances of, if he if he said on July 11th, you're going to jail for a month, for 2 months. By the way, he could put him in jail for years, in theory. But if he said, I'm going to put you in jail for 60 days, Trump's lawyers would then ask Mershon or an appellate court to stay that sentence during appeal. They would say, ask for a stay. Don't let that sentence be executed until we have appealed and had a chance to appeal this verdict. And that's another matter of discretion. That's a New York law question. Do they have to?
How long would, if that was approved, how long would the stay last?
If it's approved, then he won't have to be under the sentence for as long as the appellate courts are reviewing his case, which could be years. So a stay that'll be something to keep your eye on, whether an appellate court stays execution of the sentence pending appeal.
So you've talked about Alvin Bragg's potential for us to suspect that he might be biased. What about Juan Merchan, the judge? He was found to have donated a whole $35 in the 2020 election campaign to Biden. Is his bias? It's clearly a anti-Trump, pro-Democrat. I think Trump described him as a certified Trump hater, which is a very comical way to describe anyone. How serious is that? Is his bias? How should we take this? And the whole concept of bias in this is very bizarre. That these people are elected, and it seems not right. But what's an American perspective on this?
Well, so his donation to the
and his daughter's involved in something to do with
So first of all, he made this donation back in 2020. Trivial amount, $20 or $30. But that's a violation of the rules that pertain to judges in New York and in most of the country. They're not allowed to make a donation of any kind. It's just flat out prohibited. He broke the law by sending in that donation. Presumably he didn't know. And it's pretty surprising. And the reason why you have that law is you want to preserve the appearance of impartiality. You don't want the judges donating to campaigns and then you see what their politics are, but we saw what his politics are. Is that a sufficient conflict to require under U.S. law that he be recused from the case? Probably not, even though it's a violation. It's probably not enough you have to have a very strong conflict of interest for recusal to be required. His daughter appears to have a financial stake in the election of Biden and Harris. She has one of her clients. She runs a political consultancy campaign. She raises money for folks, and among her clients are the Biden-Harris campaign. So arguably, she stands to make, and it's a significant company that his daughter runs. She arguably stands to make millions of dollars if Trump gets convicted and loses the election. So people are saying his daughter has a stake, a financial stake in this case. But guess what? Under United States law, that doesn't give the judge a conflict of interest. If she had been a minor and still living in his household, or his wife, that gets closer. But an adult child is not, again, it's not going to trip the wire of requiring. So the question here is it's not whether Mershon was required to recuse himself. It's whether he should have. And this is a case of huge importance. And it turns out he's made this donation. He's got this daughter. Should he, months and months ago, have said, I'm the wrong judge for this, because the country needs a judge who looks impartial and doesn't have any. Yeah,
because aren't all jury are vetted to be? I mean, I don't even know how they could possibly have got a jury for that case.
Yeah.
So you'd think the same would be the case for judges. There's so much to possibly discuss, and as I said, I'm very keen to get to Bannon, Hunter Biden, and Biden, Missouri, your case. But just for a little bit of context, the 4 indictments of Trump, because that's the context here. Why is it that this one? So the other 3 are what happened in Georgia, state indictment in the 2020 election interference case, which the trial has not yet been set. Have I got that right? No, I thought we already had that one.
No. You are absolutely right. This is the crazy case happening you're talking about the Georgia case, right?
Yeah.
Where the prosecutor there, again, a local prosecutor elected to office, just committed all kinds of crazy shenanigans, like appointing a special prosecutor who doesn't have any experience with these cases, and then apparently having had an affair with him, and then apparently like sharing expenses and travel expenses. We were all reading about this in the United States. I don't know if you were. That whole case has now been put on hold by appellate judges saying, hang on, we got to look into this and see whether she has to be forced to recuse herself, because this is just crazy stuff happening down in Georgia. So that case will never come to trial before the election.
Okay. But it might do after. But unlikely.
In theory.
Okay, then there's the classified documents case in Florida.
Mm-hmm.
When that was happening, it also emerged that Biden had classified documents in Delaware or wherever at home.
Mm-hmm.
And I even remember Trump sort of making fun of him, say, oh, but they were much safer, my classified documents at Mar-a-Lago. Anyway, I know I should not do the terrible impression. But how important is that case?
Well, it's very important. But what happened there? So Jack Smith, the special prosecutor, he was trying to get that case prosecuted. He wanted it on the books. He wanted a conviction before the election. That's how it looks from an outside point of view. And it looks like that case also will not go to trial before the election.
Uh-huh.
And the fact that Biden also looks like he took classified documents and put them in his home, this is just what looks so bad. You just cannot have this kind of weaponization of the judicial process for political purposes and expect your legal system and your democracy to survive. You can't have this. And this is the I'm not sure you guys are following this, but a special prosecutor was appointed to look at Biden to decide whether he should be charged with, misclassifying or taking classified documents. This is the case where the special prosecutor eventually reported, yes, he probably committed an offense, but President Biden is a kindly old gentleman with some memory problems, and it just wouldn't be suitable to prosecute him because the jury would look at this individual and would never prosecute.
So he can run the country.
Oh, exactly.
But
exactly. Right.
What?
Yeah.
And the last indictment is the federal indictment. This is in D.C. 2020 election interference, and the case that he was interfering with peaceful transfer of power and fraud, co-conspiracy, something to do with fraud in the election. How have I got this wrong?
You have it right. This is the case. This is the January 6th case against Trump. It's located in Washington, D.C., and it accuses him of fraudulently claiming that the election, that he won the election, that he didn't lose, and it accuses him of encouraging and egging on people to come into the Capitol and obstruct the vote count, the electoral vote count that happens in Congress after an election. So this is the January 6th prosecution. Now, this case is currently before the Supreme Court, and there will probably be a decision this week or next week or the week after. And the decision from the Supreme Court that everybody's waiting for will be on presidential immunity. And so on the first question, the practicality, will this case go to trial before the election? No, because what Trump's lawyers were doing is stalling. They were stalling all these cases. That's what any good lawyer would have done. And that's what they did. They used every motion they could to drag these cases out. But many of these motions were plausible because in many of these prosecutions, the prosecutors were doing things that had never been done before. In the Georgia case, for example, it was being prosecuted as a racketeering. He was being prosecuted for racketeering offenses by this Fannie Willis. She's the prosecutor down there. And the whole case was crazy. It should never have been charged that way. So these prosecutors are doing unusual, novel things, and that gave Trump's lawyers the occasion to say, well, hang on, you can't do this, you can't do that, and that would take months for courts to resolve. Here, what Trump's lawyers are saying is the president is immune from prosecution. This is a big deal. Under what conditions?
That doesn't sound right to me. Why should the president be immune from prosecution?
Well, in my opinion,
no one's above the law.
As a constitutional professor, a law professor, I'll tell you that it can't be that the president is categorically immune from prosecution. President, former president, no one's above the law. Again, if a president clearly committed a crime while he was in office. Like he got on the phone and he ordered a hit on his opponent in an election. And you've got the goods on. You got a tape of the call. Of course a prosecutor can go after the president for that. No one's above the law. The problem is what happens in these cases when they're going after the former president on novel legal theories that have never been used before. That's dicier. That's trickier. That's a more dangerous precedent to set. But the issue before the Supreme Court will be under what circumstances can a president claim immunity?
It's super. Even the charges in that are super vague and
very complicated.
Because if you look at what he says we're not like the other side. Even if you go through his tweets again, he says no violence, respect the men and women in blue. As my memory is, and this is from the January 6th committee as well, is that he failed to stop them from doing it, which is a bizarre thing, because then wouldn't you say, well, the security failed to stop them? Loads of people fail to stop things, and if that becomes a legal something, you can actually charge someone failing to stop something. There's endless the legal consequences of that. So,
well,
anyway,
again,
I know it's very vague, but maybe
you're hitting the nail on the head again. I've looked very carefully at the statements former President Trump made on January 6th, as lots of people have, and this is a First Amendment question. He has a right to criticize the election just like any American does, and to say he thinks that there was fraud in the election, and he has a right to even to call for people to protest. He can't incite a riot. And
he definitely doesn't incite a riot, because he says go peacefully. Yeah. Like he says that again and again and again.
If you look very carefully at what he says, it doesn't look to me like he crossed the line of inciting violence, which means that there's a serious First Amendment problem. Like, you can't throw somebody in jail because of his political statements that he thinks that the election had fraud in it. That's not a crime to say that that's what you think.
Yeah.
And so there's a serious First Amendment problem there. His lawyers are making this immunity claim. That's what's gotten to the Supreme Court. That's what has delayed the case. What happened there, to give you 30 more seconds on that,
yeah.
The lower court said there's no such thing as presidential immunity. Once they leave office, essentially the lower court said there's no such thing. We don't have presidential immunity. I think the Supreme Court may narrow that and say, oh, no, you can have presidential immunity in certain circumstances. And they're going to lay out, some new test for presidential immunity under what circumstances. It's also possible that the Supreme Court will simply straight up say Trump is immune from this January 6th prosecution. That would be the most extreme result that the Supreme Court might come down with in the next day or two or next week. And that will be a very serious holding if the Supreme Court says that. I don't expect them to go that far, but they've been looking at this immunity issue for months now, and I expect them to say something that I expect them to reverse the lower court, but what we don't know is how far they'll go.
So just as concerned you are as the precedent being set in the New York case, you are also concerned by the potential precedent being set on this. So there's bad precedent on both sides really here.
Yes.
Do you think that's a fair statement for me to make? Or?
Yeah, absolutely. My view is no one's above the law. The president cannot be categorically immune from prosecution for acts taken while in office. I think almost any American lawyer is going to agree with that. Again, whatever you think about Trump. But on the other hand, you can't have a former president and leading presidential candidate being prosecuted by Democratic officials in many of these prosecutions on the basis of novel legal theories that have never been used before and that you can barely even explain. That's a very serious problem in a democracy, and that's what we're facing right now in the U.S.
Just a small point, just to go back, because part of that is that he didn't accept the 2020 election. It's worth noting that Hillary as well was calling into question the legitimacy of the 2016 election through the fabricated Steele dossier. So there's sort of, it seems to me that there's various hypocrisies going on both sides. Is there anything else in the indictments you think that we should cover for the audience before moving on to Bannon?
I think we've done a good job with the Trump issues.
Okay.
I mean, there are also civil cases against him brought again in the state of New York with a $500 million judgment.
Can you tell me about that?
Well, it's just I could, but it's too complicated. But I mean, so there's a concerted effort to, by officials, state officials, elected officials, to do everything they can to try to take him down. And we have to be very careful before letting officials do that to a presidential candidate from the other party. They got to turn square corners. Everything. I'm not saying they can't do it. What I'm saying is you got to be very careful that it's lawful, constitutional. They're doing everything by the book.
So, Steve Bannon, former strategist for Trump when he was president for 7 months, has been ordered to hand himself in for prison term on July 1st because he was found in contempt of Congress relating to the Jan 6th committee hearing. There is another man who is currently doing 4 months, whose name is...
Navarro.
That's it, Peter Navarro.
Mm-hmm.
For the same crime, I believe.
Mm-hmm.
What do we need to know about that case?
Well, again, the question in everybody's mind is it politically motivated? Nearly nobody ever goes to jail in the United States for defying a congressional subpoena. It hasn't happened in about 50 years. So it's unusual. And so, a lot of people are saying it's outrageous. They're going after Bannon and Navarro, but they didn't go after anybody else. This is, again, political prosecution. And it might be, but so basic facts are these, just so your audience understands. The January 6th committee got Congress to issue a subpoena to Bannon to turn over these documents. Mm-hmm. We want to see these documents. And Bannon said, no, I won't do it because these are covered by executive privilege. I don't have to do it. And he was found to have defied a congressional subpoena, which he did. And that's a crime. If the Congress asks you to produce documents, you got to do it. Mm-hmm. Now, if he had a clearer claim of privilege, maybe he doesn't get prosecuted here. But the Department of Justice takes the following position. They say, we won't prosecute an executive official who defies a congressional subpoena on the basis of executive privilege. But the problem with Bannon is he was never an official at the time when he defied the subpoena. Mm. And you can look back at the Department of Justice prosecutions, and they have adhered to this line pretty well. So Bill Barr, Trump Attorney General, he also defied a congressional subpoena, and he did so on the basis of an assertion of privilege, executive privilege. He said, no, you're not entitled to this, Congress. This is presidential stuff. We don't have to turn this over. And the Department of Justice has not prosecuted Barr. They say, we don't prosecute an official if he claims privilege and has some ground for doing it. But they say, Bannon, he wasn't an official when he did this, so we're just following our usual rules. So it's going to be harder to show selective prosecution here because the DOJ, Department of Justice, has a set of guidelines, and they appear to be following them. Now, that said, it's still the case that nobody ever gets thrown in jail for these things. It looks bad. No, nobody's been put in jail for 50 years in the United States for defying a congressional subpoena. And now all of a sudden it happens to Bannon and Navarro based on the January 6th stuff.
Has that happened often?
No.
But sorry, what I mean is that being found in contempt of Congress, is that a regular thing, or is it?
Well, Congress often feels that people are not suitably responding to their subpoenas, and they often pass resolutions of, we find you in contempt. They just recently found Attorney General Merrick Garland in contempt for the same thing. And the DOJ says, we're not going to prosecute Garland. And everyone's upset, well, you went after Bannon, and now you're not doing So Garland was subject to a congressional subpoena, and Garland said, I'm not turning over those documents.
On what issue?
They wanted Garland to turn over the transcript of Biden's meeting with this special prosecutor, the one where that makes the special prosecutor say, this guy's a kindly old gentleman who doesn't really remember very much. And Garland says, I'm not turning over that transcript to you. And Congress finds Garland in contempt and says, you have to. And he says, well, I'm not. And so Congress finds him in contempt. And the DOJ says, we're not prosecuting Garland. And the DOJ says, because Garland's a federal official, and we don't do that. And so they're adhering to their rules, but it all looks bad. I mean, Garland defies the subpoena, no problem. Bannon defies the subpoena, he's in jail. Navarro defies, he's in jail. So it looks bad.
Do you how biased is the DOJ then? How serious an issue is DOJ bias in America?
It's so hard to know, Winston, and you're asking a great question and one that I have a hard time answering. I've worked for the Department of Justice. I want to believe in it. I do not want to believe that it is corrupt and political down to its core. I don't want to believe it. I do not believe that Merrick Garland is a corrupt person. I believe that he is doing what he thinks is right. But you see disparities. You see January 6th defendants, hundreds of them, sentenced to jail. And I'm just going to take an example here. You don't see as much prosecutorial action against people who participated in the BLM riots of 2020. Now, why is that? This is not the way things should work in a fair and just system that needs to establish its impartiality and to show you that it's not behaving as a political weapon. And a lot of people are getting worried that our Department of Justice is now looking like it's a weapon in a political toolbox, and that's a disaster for a legal system.
So we've now looked at two cases against, I guess, what you would say, the MAGA movement. There are two cases, big cases, against Biden. One is his son, and the other is the Biden, Missouri case, which you're a lawyer. Let's start with Hunter Biden. He's just been found guilty of 3 felony counts to do with owning a handgun whilst being a user of crack cocaine.
What he was found to have done was he lied on his application to buy the handgun and said, no, I don't use drugs, because you got to answer that question. When it turns out, I mean, the very, very strong evidence, and the jury found that he was using illegal substances at the time when he said he wasn't. So it was the lie on the application that was the felony violation.
So there's quite a few things going on here that are worth picking out. Firstly, the evidence is the laptop, the famous laptop. And by the way, Wikipedia, if you look up the Hunter Biden laptop on Wikipedia, it still calls it in the title the conspiracy theory about the Hunter Biden laptop. We have been told for a long time, well, it's an episode for another day about how they tried to censor the Hunter Biden laptop story across social media. It was a couple of years ago now, I think, that finally the New York Times at least admitted it was real. But now we have it in court that they're using the laptop as evidence. This is another thing. I mentioned the peace story earlier. The peace story, which is still believed by a lot of Americans and people across the world, for which there is no evidence. And the person himself who said he came up with it said he had no evidence. There are people who don't believe the laptop story, even though we've had these photographs of Hunter Biden and videos doing crack cocaine with prostitutes, and it's clear as day. But anyway, so finally, the laptop is no longer a conspiracy theory. It's been used as evidence against him. So that's one sort of aspect to this. But I think perhaps the more important aspect is the plea deal, and I want to understand, because before the case, Hunter Biden went into a plea deal which meant that he couldn't be prosecuted for any other federal or any other crimes if he agreed to do this one. Now, given what else is on the Hunter Biden laptop, for example, the many emails not only to business associates in China, but also Burisma Energy Company, on which he sat on the board, including the famous email which says 10% for the big guy. So there's a question about corruption there, and this is whilst Joe Biden Sr. was vice president. There's a question of corruption. Now, you might tell me actually technically there's nothing illegal that's happened there, and I'm interested to know that. So this plea deal, what is the significance of this plea deal? And is this, am I over-egging this, or is this quite important?
Oh, it's very important. The whole thing is so embarrassing. What a mess. But so some people are saying that the prosecution and conviction of Hunter Biden for this gun offense shows you that, in fact, the Department of Justice is not weaponizing. They're totally fair. They've gone after the son of the president. What else do you need as evidence to prove that Merrick Garland and the Department of Justice is working fairly and wouldn't ever use, its prosecutorial powers in a political way? So a lot of people are saying this is a great thing that shows how neutral the DOJ, Department of Justice, is. But the story is much more complicated, and it's complicated for the reasons you're saying. What happened was the Department of Justice struck a plea deal with Hunter Biden. This goes back over a year, in which Hunter Biden wasn't going to have to plead guilty even to any felonies, just misdemeanors, and have essentially no record at all. And what happened at that point with that complete sweetheart plea deal was a couple of IRS, Internal Revenue Service, tax officials, whistleblowers, came forward and said, the Department of Justice is interfering with our ability to look into and investigate and potentially prosecute Hunter Biden for tax offenses, because we can see he hasn't been paying taxes on all this money for years. And that worried the Department of Justice, it seems. And after those whistleblowers came forward, and by the way, they were also saying, and in addition to tax offenses, we're seeing evidence of serious corruption at the highest possible levels, hinting at Biden himself. And after that, the DOJ said, okay, we're going to have a little more serious plea bargain. We'll make him plead guilty to some serious, drug, to at least one serious, drug offense, and maybe a little tax offense, but that's still a sweetheart plea deal, and the plea deal looks like it's saying, and we can never prosecute him for anything else, including the corruption crimes. If he just pleads to these little, gun and tax offenses, he's scot-free. We won't prosecute him on the corruption charges. This gets to a federal court, and normally federal judges are rubber stamps for plea deals. They don't usually look at them that carefully. But this judge says, she's looking at this plea deal and says, wait a second, in return for these little admissions, are you actually saying that the federal government can never prosecute him for anything else again? And Hunter Biden's lawyers stand up and say, yeah, that's what it says. That's the agreement. And the prosecutors are embarrassed. They say, oh, no, not necessarily. And Biden's lawyer said, what are you talking about, not necessarily? That's what the agreement says. And it blows up in court. It was going to be another sweetheart plea deal. That blew up in court. The judge said, I am not signing off on this. And that's when suddenly the DOJ suddenly prosecutes him for the felony gun charge. And they're also getting ready to prosecute him for tax offenses. Mm-hmm. But it's only because the sweetheart deal that was going to let him off of everything got blown up, not once but twice. So I don't think this is a story of DOJ neutrality and showing how unbiased they are.
Huh. What part of what's your take on the Hunter Biden laptop and the evidence of now President Biden? He was VP, and the possible links with Ukraine. Is there anything that's illegal about the vice president taking meetings with his son's business associates? Is that illegal?
Well, it could be. It sure could be.
Are there any corruption? What are the corruption laws?
Here's what I want to say about it. We don't know the facts. We don't know nearly enough about the facts. So I'm not going to opine about whether laws were broken, but in principle, you cannot be selling a public office. I mean, look, if it's true that Biden was taking money, like 10% for the big guy, taking a piece of these deals while he was in office, I mean, that would be crazy level of illegal, corrupt activity. But if he's even, if he's allowing his office to be used as an incentive to help his son out, these would be very serious in these foreign business deals. This would be a very serious potential charge. And but we don't know what the underlying facts are. And, and you have to, that's why we need what I want to say about it is we shouldn't, I don't want to jump to a conclusion about it. The answer to your question is yes, there are very serious potential corruption violations here. They're very serious potentially, but we don't know what the facts are yet, nearly well enough for me to state any conclusion about it.
Let's go to Biden, Missouri, or Murthy, Missouri, your case. Now, actually, maybe we could start by you explaining your involvement in the case.
Sure. Well, I got to tell you, I, in my opinion, this is one of the most important First Amendment cases that the court has ever had, the Supreme Court has ever had before it. It's going to be deciding this case at any moment. It could come out today. It could come out tomorrow or next week. In this case, plaintiffs are suing the Biden administration, which pretty clearly the facts show had engaged in a massive campaign to induce social media companies. And we're talking about the big boys here. Mm-hmm. We're talking about Twitter and Google and Facebook to censor speech that the administration didn't want folks to hear and didn't want anybody to be able to say. And they did this for years. And the suit says this is unconstitutional. It's a First Amendment violation. It's a form of censorship. Now, under the U.S. Constitution, our Constitution doesn't apply to private companies, not if they're acting on their own. If Facebook decides to censor stuff, that's not a constitutional issue in the United States. It's only if the government gets involved that it becomes a constitutional issue. If the government is pressuring Facebook or working closely with them together to censor speech, if they have a partnership, if they're colluding, then it becomes a constitutional issue.
Is that the actual language they use, pressuring? Because it's quite key, the language, isn't it?
Yes.
What is it in?
So the plaintiffs allege, and I am a lawyer in this case, so you could say I'm biased, but I got involved in the case because I believe in the position we're taking. There's a ton of evidence that has come out, including in the Twitter files, of government officials, White House officials, pressuring social media companies to censor individuals and content, especially COVID-related content. But also, by the way, the Hunter Biden laptop story. Mm-hmm. So you have FBI officials going in to Facebook and Google and inducing them, getting them to believe, trying to make them believe that the Hunter Biden laptop is a Russian hoax.
Zuckerberg admitted that's why they Facebook
absolutely because all of this, there are connections between these matters. Look, it's a kind of technological and economic accident that 3 or 4 companies have this much control over public discourse. No company in the history of the world has ever had as much control over public discourse as Facebook, Meta, and Google have. And no government has ever had as much control over public discourse. That's an accident. It's no accident that the government wants to get involved and use that power to suppress ideas and to suppress facts that are inconvenient to the government or that are critical of its policies. And they've been doing it on purpose. And I started saying about 5 years ago, their involvement in this censorship is so significant that it crosses a line. And when social media companies censor this speech at the behest of the federal government, that's a constitutional problem. That's a First Amendment violation. And that's what this lawsuit that you're talking about says. And so the theory of what the case was, you guys have been inducing social media censorship. That's unconstitutional. And we want a court to order you to stop. Mm-hmm. And we won. In the lower courts, we won. In the Supreme Court, I'm pessimistic. I'm worried we're going to lose, and we're going to find out in the next few days.
So where is your pessimism coming from?
The case gets argued on appeal. Again, I'm getting into the weeds here. Stop me if it's too much.
No, this is crucial.
It gets to the Supreme Court on one particular theory, a theory of coercion, a theory being these government officials coerced Facebook and Google and Twitter to censor stuff by threatening them with, we'll break you up under the antitrust laws. We'll do this. We'll harm you if you don't censor this stuff. Okay. If the government did that, if they coerced them, that's clearly unconstitutional. That's the theory that the case goes up to the Supreme Court on. And it looks like, based on the arguments in the Supreme Court, it looks like a number of the justices weren't convinced that the coercion line had been crossed here.
Is coercion the word used in the First Amendment?
No, it's a word used in the case law around the First Amendment. So cases the Supreme Court has held for 70 years that if governmental officials coerce somebody, a private party, not to carry somebody else's speech or to suppress somebody else's speech, that's a First Amendment problem. And
so is coerce a vague word? What is coerce taken to mean?
It's a very vague...
How would the courts define the word? Sorry to be super semantic, but it seems quite crucial.
It's the question of the case, and the court may articulate a definition of it. The way folks...
let me explain why I think it's crucial to the case. It's because if you get a letter from the government through your letterbox saying you're obviously entitled to say what you want, but don't say this, and it's got the government letter, let's say you're a regular person at home, you're going to feel like technically they haven't coerced you, but you're going to feel the implicit pressure, and coercion can be implicit, can it not? So if you get an email from the government saying, you're allowed to do what you want, but we think this is X, Y, and Z, or this is Russian disinformation, or this is not true, this is disinformation. There's an implicit coercion, is there not?
So the law in the United States on this is that an implicit threat counts as coercion. It doesn't have to be explicit. So, the government writes a letter or calls up and says, nice social media company you got there. It'd be a shame if we had to break it up under the antitrust laws. Right. And by the way, that anti-COVID vaccine speech that you're posting, we'd really like it if you suppress that. That could count. The question the courts have said is whether a reasonable person would understand the government's communications to be communicating that there's a threat, and it could be explicit or implicit. And what I'm worried about is that the Supreme Court justices in this current case, on the current record, are going to say we don't have enough evidence of coercion yet. But I want to stress this. Coercion isn't the only theory that's not the only way that the government can turn a private party's action into a First Amendment violation. If they collude with them, if they work closely, if they, form a partnership with these private companies, which is what they're doing. They're turning these companies into, their censorship field offices, and they're working, and they identify which people they want suppressed and which ideas they want suppressed. And so a different theory of the case is, and you can have both. They were both coercing and they were working together. They were conspiring. They were colluding together to form a censorship partnership. And I believe that actually both were happening here. But if the Supreme Court says tomorrow, we don't have evidence of coercion in this case, the case will not be over. I'm a lawyer in the case. I represent Robert F. Kennedy Jr. and other plaintiffs.
What's Kennedy's
Kennedy is probably the most censored person on social media. He's about as censored on social media as anybody else in the United States. And we have evidence that governmental officials named him by name, as well as some other people, and said, get this guy off of his Facebook account, terminate his Facebook account, terminate his Instagram account. Don't let him post these videos.
I've heard RFK Jr. also say that or claim to be the first person that the Biden administration censored when Biden came to power.
Days after the inauguration, we have an email from the Biden administration, from the White House to Twitter, I think it is. I can't remember whether it's Twitter or Facebook, naming Kennedy and saying, we want this post taken down.
Was it a vaccine post?
Probably. I'm not sure of the details. As everybody knows, Bobby Kennedy has been saying for a while that the COVID vaccines weren't sufficiently tested, and that they might be dangerous. And for about 6 or 8 months, you were not allowed to even say those things in social media, or you'd get your account censored. Just as you could not say for about 6 months in 2020 that the COVID virus might have originated in the lab in Wuhan on the basis of possibly U.S. funding help for gain-of-function research. You couldn't say any of that stuff. It would be taken down.
You could say, on the other hand, the way more racist thing that it came from a wet market, as if Asian people, have these kind of base eating habits. But the less racist version, you can't say. But anyway, sorry.
If government can get behind the scenes into a partnership with the big social media companies to censor speech, controlling what hundreds of millions of people can say, see, and hear every day, we're going to lose hold. We're going to lose the freedom of speech. And I worry that that's exactly the world we're living in right now. And the win that we secured in the lower courts, saying to the government, you can't do that anymore, was a huge victory for the freedom of speech in the United States. And I'm worried that the Supreme Court's going to reverse it in the next few days.
So your involvement with RFK Jr. on this specific case is to do with that first censorship from the Biden administration?
Yes.
Okay. And then that sort of snowballed into this bigger thing, because I know that Dr. Jay Bhattacharya and Martin Kulldorff, they're both involved in this case.
They're also plaintiffs in this case.
Right, okay. And if, I know you're pessimistic, but let's say the Supreme Court rule against Biden, what does that mean?
What the Supreme Court should do, or what the court should do in a case like this, in my view, this is what I've argued, they should say, look, of course you, President Biden, you're permitted to express your opinions about COVID, and you have the same right as anybody else to express your opinions in public statements about the COVID vaccines or where COVID came from. But what you and your officials cannot do is get on the phone with social media companies and talk to them in an effort to induce them to suppress particular people or ideas that are First Amendment protected. That's the kind of injunction that I'd like to see the courts issue. You got to just stop this business where you're on the phone. They were meeting with them every week, and they were telling them, look, this is the stuff we want you to take down. These are the ideas we want you to not let be expressed, and these are the individuals. And what I would like, ideally, would be an injunction saying that's what you can't do. You can't get on the phone behind closed doors with these social media companies and work with them to try to induce them to suppress particular people or ideas that are protected by the First Amendment.
Also worth noting that the Trump administration, whilst he was still president, were also emailing, and this was exposed in the Twitter files as well, so it was not just Biden administration. But my question... Okay.
Oh, this is a very good point. This is not a partisan issue, in my opinion. This is a free speech issue, and I don't care who's doing it, whether it was the Trump administration or the Biden administration. It's unconstitutional, and this is the world that we're now living in. Governments all over the world are seeing the possibility of controlling public discourse through the intermediation of the big social media platforms. Governments all over the world are seeing the potential. Governments always want to suppress speech. Mm-hmm. They always want to suppress dissident. Every government that's ever existed has wanted to not let people criticize them. And now they have a vehicle they've never had before for doing so. And we need to wake up, and courts need to draw lines saying this far you can go, but not past this line. Mm-hmm. And this is, for me, not a partisan issue at all.
Specifically, Joe Biden, if you win the case, what does that mean for him as sitting president?
I don't think it has a big implication for if
he's found to have broken the First Amendment.
Mm-hmm.
You don't think it's got a big implication? Doesn't affect his presidency?
Well, if we're asking just like the practical political question, will Americans change their votes based on...
No, I'm not asking that.
That's what I thought you were asking.
No, what I mean is as a sitting president, is there any law that he can break that would affect his being president?
It's a great question you're asking. I don't quite know how to answer. I mean, there are many people in America who strongly believe that misinformation should be suppressed online. And it's a good thing for the government to get in there with social media companies and say, look, we're experts. We can tell you what's true and false about COVID. And of course you should suppress the false stuff. What's wrong with that? Of course, what's wrong with it is you can't trust government officials to tell you what's true and false. That's the whole point of freedom of speech, is you don't want the government to be in a position of saying what's orthodox and what's not orthodox. But there are plenty of Americans who think that was great. That was good what they were doing. And I don't think their views will be changed if the Supreme Court says, no, we think this crossed the line into a First Amendment violation. I don't think
so. A sitting president can be found to have been broken the First Amendment, and it doesn't actually make a difference to his...
as a practical matter, I do not think this will be a vote shifter. I could be wrong, I don't know. But that's the question I thought you're asking, and I don't think.
No, I wasn't asking as a vote shifter. And then I'm reminded, of course, that all the while Trump, his speech is being, and part of the indictments is coming under question, particularly around Jan 6th. There's a whole blur of things all happening simultaneously. And you've done a great way of showing how intertwined these various cases are. Now looking back, looking over at all of them, Trump, Bannon, Hunter Biden, and this Biden-Missouri case, do you think, the impression I've got from hearing you speak is that there's a pretty strong bias against basically the MAGA populist movement. Do you think it's fair for me to have come to that conclusion, or is there actually, is the other side being served justice to some extent that you think is fair? Or do you think it's swinging one way? What's your impression?
I'm very worried about it. And I think every American should be. I mean, as I was saying before, it's a disaster for a legal system and a democracy to allow the prosecutorial system, the justice system, to become a weapon in a political battle. I'm very worried that we're going down that path, and I don't know what will happen if we do. But I've been teaching constitutional law for 30 years. I still believe in the American Constitution, and I still believe in the Supreme Court. Just a few months ago, the Supreme Court ruled unanimously that Colorado, the state of Colorado's effort to disqualify Trump from the ballot was unconstitutional. Unanimously. It wasn't, thank God. The 6 conservatives rule one way and the 3 liberals rule another. That would have been another disaster for the country. It would just have reinforced the idea that it's all politics. There's no law. It's all partisan politics all the way down. But no, they ruled unanimously. And I got to tell you, my colleagues at Yale Law School, they were all saying, of course, what Colorado did is fine. It's great that they're disqualifying Trump. I mean, this is shocking to me. From my point of view, it was clearly unconstitutional. And your colleagues were saying it's great. Oh, it was great. And they were making a defense of it and saying that it was totally constitutional. And here are the reasons why. And the Supreme Court batted that view down unanimously. And for me, this was a moment that encouraged me. And just a week ago, the Supreme Court ruled unanimously that government officials in New York pressured unconstitutionally banks and insurers to stop insuring and doing banking business with the NRA, the gun
lobby
group, gun lobby, and they ruled unanimously that was unconstitutional. It was a First Amendment violation because the New York officials were pressuring private parties to retaliate against the NRA because of the NRA's political positions about guns. That was unanimous. So again, I just don't want to believe that our legal system is now hopelessly divided by partisan politics, and I still do believe in the American legal system and the Constitution, and I'm not ready to give up on it.
Well, thank you. It's clarified some things, although speaking to you has also given me the impression that this is way more complicated even than my initial peeking through the cracks of this. Jed, is there anything with relating to this that you think is key that we missed?
I don't think we've missed anything. I think we all know that we're living in perilous times, and part of the peril is the division, the divisiveness of partisan politics, and we need voices that try to rise above it, and we have to fight to not give in to it, and I'm trying to help in that fight.
Well, more crucially still, we need a legal structure and legal code that will be applied to your enemy just as much as applied to you. I hope people remember how important that is. Jed, where can people find you? You've got to tell them about your YouTube page.
Well, thank you. Yes, I have a YouTube channel, and I have a podcast and I guess the name of the channel is Straight Down the Middle. And you can find me on X, and you can find me on YouTube, and you can find me on TikTok a little bit. What I'm trying to do through those videos and podcasts is simply explain to people, walk them through these cases. If you listen to these episodes, for example, you'll learn what exactly Trump was prosecuted for. Mm-hmm. And I try to keep it straight down the middle. I raise the constitutional issues so that people can understand what those issues are, and they can form their own answers or opinions about it. Mm-hmm. But so I explain the cases because everyone's so confused. Nobody knows what's going on. So what I try to do is explain the cases, explain the issues, and then let people decide for themselves.
Great. Well, Jed Rubenfeld, thank you for your time, and let's do this again.
Thank you, Winston.
Thank you for watching The Winston Marshall Show.